Okay, good afternoon, everybody. This is your Committee on Education. Today's date is February the 3rd, 2:00 p.m., and this is room 309. We have a dozen proposals on the agenda today, but first, it's Superintendent's birthday. One, two, three.
Happy birthday to you. Happy birthday to you. Happy birthday, dear Superintendent. Happy birthday to you. What's your birthday wish, Superintendent?
Now for the grilling. No. I'm just kidding. Okay, so we're going to go into our first agenda item. That's HB 1895. This is with regards to educational worker protections. First up, we have Field E Superintendent in support.
Good afternoon, Chair Woodson, Vice Chair Lachiko, members of the committee. Sean Tajima, Assistant Superintendent, testifying on behalf of the Department of Education. The department stands on its written testimony in support of this measure. Thank you.
Thank you so much for being here. Next, we have HSTA offering testimony and support in person.
Aloha, Sarah Miliantalatan, on behalf of HSTA and President Osatulu Jr. We support this measure. Thank you, Chair and Vice Chair, for hearing the bill. I'm here as your teacher lobbyist this session. The way that this works is I'm here to talk to you as a practitioner, someone actively in the classroom. So if there are questions you have, please let us know. We know since COVID, issues have increased when it comes to harassment in ways that they haven't. So it's really important that we're talking to teachers about what's going on. We also know that bills have come previously in previous years that want to make this a big issue, and we hate that it had to be on the news to be addressed, but it's something that we're glad that we're talking about this issue.
Thank you for being here. Next, we have HGEA offering testimony and support.
Hello, Chair, Vice Chair, members. Nui Sebastian with HGEA. I will stand on our testimony and support. I just do want to mention that we represent thousands of employees within the department, and every year we do get calls from employees of them experiencing harassment or assault. So we appreciate the intent of this measure, and we hope this serves as a further deterrent against bad actors. Thank you.
Thank you so much for your testimony. Next, we have Kaneohe Elementary School Principal offering testimony and support. Not present. We have UPW testimony and support. And then we have 4 individuals all offering testimony and support. Is anyone here wishing to provide testimony? Any individuals? Okay, please come up and state your name.
Can you hear me?
Yes.
Aloha, I'm Tiffany Edwards Hunt. I'm a student activities coordinator at Kea'au Middle School on the Big Island. And I'm here to testify on a number of legislation. So.
Okay, we're just doing right now HB 1895.
Okay, so regarding HB 1895, I just can't speak more in favor of it. And I want to explain to you that Millie is correct. The harassment and assault of educational workers is very real. As a student activities coordinator, I've had to kick students out of a school dance for vaping and then have their parent right in my face screaming and yelling. For me, I can handle it, but other teachers have been so traumatized that they're then afraid to chaperone. We'll break up a school fight, and then the parent is in our face screaming and yelling, threatening to sue us. So this is so real and so important. Yes, I have so much sympathy for the coverage on the news. And yes, I guess it took that to bring it all to light, but we are dealing with some really scary times where people just do not have decorum anymore. And it's so important that we have those safeguards. Thank you for the opportunity.
Thank you so
Aloha.
much. Anyone else wishing to provide testimony? Please come up.
Hi, good afternoon, Chair, Vice Chair, members of the committee. I apologize. My name is Haley Chang. I'm the first deputy from the Office of the Public Defender. I do believe we submitted testimony, but I apologize, it may have come late. I do first want to introduce myself. We don't appear in front of this committee very often, as we are the agency that represents indigent individuals in criminal matters throughout the state. And we did submit opposition to this bill, but I do want to caveat the reason why. We absolutely support the sentiment and the purpose of this bill, but our job as advocates in the legal system are to highlight certain issues that we see with any proposed criminal measures, and we do see that here. We absolutely understand and support the necessity of protecting and maintaining the safety of our educational workers, but we question whether or not this bill actually does that. This bill does not achieve that purpose, in our opinion, and opens the door to several significant and major constitutional challenges, including the freedom of speech and the overbroad and vague nature of the bill. I want to focus particularly on subsection G, which adds additional conduct to the offense of harassment, and it states that harassment can be considered disruptive or any behavior that disrupts or interferes with the administration or functions of any school, school administration, or school board. From a legal standpoint, that language is not going to withstand constitutional muster, and the legislature would not be doing anyone favors to pass a measure that would not achieve its intended purpose. Disrupts or interferes specifically is especially problematic. Is a parent interrupting an educational worker during a discussion disruptive or interfering? Is that the purpose of this bill? Is a parent repeatedly calling the school office disruptive or interfering? Is a guardian showing up without an appointment disrupting or interfering? And we understand some of the egregious behavior, and that's not what we're speaking to. We're speaking to some of the flaws that are potentially here because of the way that the bill is worded. As written, this language of this bill risks criminalizing ordinary parental advocacy, potentially student speech, and sometimes normal, not egregious, but normal emotional responses to school situations. The preamble to this bill says that this is not intended to restrict good faith communication, parental advocacy, or participation in school matters. But in our opinion, from the legal standpoint, and from the agency that defends criminal matters, it does not achieve that purpose. So we again support the spirit and the intent of this bill, but we do not believe that legally this is the way to achieve it. I appreciate the opportunity to comment, and I will be available for any questions.
Thank you for being here. Anyone else wishing to provide testimony on HB 1895? Seeing none, members, are there any questions? I have a question for the public defender. And so when you say that it's a potential violation of freedom of speech, what do you mean by that specifically in the legal sense?
Well, there are the case law, both at the federal and state level, on the freedom of speech is very clearly articulated. And what we don't want to do is potentially cause civil right of action or violate someone's constitutional right. So if you're asking me generally what is an infringement on the freedom of speech.
I said specifically in the bill what violates freedom of speech.
Well, again,
from a legal standpoint.
From a legal standpoint, the language of disrupts or interferes. A disruption or an inconvenience does not mean that you, or maybe I should characterize it as an inconvenience, a potential inconvenience or a disagreement or a different vantage point or a different opinion or viewpoint does not necessarily mean a disruption or an interference, and you are constitutionally allowed to share those opinions in an appropriate way.
So how should we structure the bill to meet that constitutional standard from your perspective?
Well, I think as what's been highlighted by the testimony of some of the others in support, the really egregious behavior is what we're concerned about. It is, as the one testifier said, the screaming in a parent's face, which we believe is already articulated in the harassment statute. As indicated in the measure, you can see all of the different categories of behavior that already constitute harassment. Strikes, shoves, kicks, insults, taunts, or challenges. Those verbal and physical responses are already levels of harassment. I know this bill is seeking to elevate the offense from petty misdemeanor to misdemeanor. That is a different conversation, but in terms of what type of behavior or what language can be used in the bill to make it so we are appropriately punitive, I think the measure already, the existing statute already covers that.
So if a individual says to an educator, you know, I don't like what's going on at this school, therefore I'm gonna come to your house and kill you, is that covered under freedom of speech?
No, that's not, and there are criminal statutes. There's, I mean, again, it's a very legally complicated hypothetical you gave, but for example, there is a terroristic threatening statute on the books, which is a criminal offense. A verbal threat that puts someone in fear legitimately is a misdemeanor already. And we already have an elevation to a felony offense because educational workers are already an articulated protected class of individuals. So that behavior, as you just described, is criminal, and I don't want to say blanket across the board because legally there's a lot of nuances, but no, you cannot threaten an educational worker meaningfully, and that is protected speech.
Is the example that you gave, is that under state statute or is that federal law?
Terroristic threatening is a Hawaii revised statute under Chapter 707. And there are two levels, second degree and first degree. And normally, a threat without a dangerous instrument is a misdemeanor, but educational workers are already considered a protected class of individuals. So if you were to do that to a non-educational worker or a non-protected class, it would be a misdemeanor. But for an educational worker or other protected class, it would be a Class C felony.
Okay, thank you. Members, any other questions?
Question?
Please go ahead.
HSTA?
HGA.
Oh, I'm sorry, HGA. So you said you guys have a bunch of these come up every year. I just sat you at harassment training, and I was blown away with how simple a word could be construed as harassment. What type of training does your, the people you guys represent, teachers, administration, and the likes of, what kind of training do they have? Because there's, what I'm afraid of, if we fast forward 2 bills, I support those assaults and those 100%, but when it comes to harassment, given the training I just sat through a few days ago, I'm afraid that passion can be mistaken for harassment. I'm afraid that if there's a history of children going through the same school, that because you dealt with the older brother and the younger brother's coming in, that teacher may already not like that family. So now there's a possible retaliatory situation. So help me understand what kind of training that they go through, and if maybe your training is similar to ours. Really.
Representative, thank you for your question. I think in terms of training, I would need to defer to the Department of Education as they're the employer that is tasked with providing the training.
Thank you.
DOE,
Anybody from the DOE? So same question. How do you guys decipher the difference between passion and harassment?
I think it is very subjective. I think when we read the bill, I think with the new language that's being proposed, the department appreciates and agrees with that language. And I think when it becomes very disruptive to operations and when it's excessive and repetitive, I don't have a straight definition of what makes it cross over, but I think when it meets that threshold of becoming excessive and repetitive, we would condone that as harassment.
So like the public defender had said about some vagueness, raising their voice in a meeting. Is that harassment?
I think it could be, depending on the degree that is raised. And I
That's
think,
kind of where my question is. If I raise a voice because I'm passionate, because we're talking about my child, or anybody's child, the chair had brought up if they make a threat. That's clear and cut, that, it's black and white. But now, if they're not intending to harass or harm you, but they're passionate about what they're trying to get across to you, what's to say that that individual on the administration side is not going to just walk away and say, I feel harassed? What protections are there, or what is there for that?
I think for school level people, I think for the most part, the process allows us to be very inclusive for parent voice, and we do understand that parents are passionate about their students, and I feel that our threshold is for the most part pretty high with that. I think if it gets to the point where maybe the volume might be disturbing or bothersome to somebody, I think at that point, what's usually done is the person is redirected and asked to lower their voice. And I think if at that point it continues to escalate, then at that point maybe another round needs to be taken. But usually it'll be addressed to ask somebody to please lower their voice, because sometimes we all might raise our voice depending on what's going on, so it takes a reminder to lower it. And I think if the person responds to that, I don't think there's any issue beyond that. Because when they're not responsive to it, then it becomes an issue.
So, Chair, if I'm out of line, please stop me here.
No, go ahead.
But there's a situation right now ongoing, I'm not going to mention the school, but the teacher fell asleep in class. Two students took a picture of it. Parent called the principal, had a meeting. Now this teacher is saying that parent is harassing the teacher and making these false accusations. Photos were then provided. I was told I cannot get any info because it's a personnel situation, which I completely respect, but I don't want, you see where I'm going with this. That teacher can say that she's being harassed, but it's not harass, it's care, it's passion, it's trying to say something. So at what point does it become, I want to protect the teachers at all costs. Our teachers need it. But I just want to make sure that the parents can get what they're trying to say across as well, without harassing, assaulting, or endangering teachers. But if I get a little loud because I care and I don't think you're hearing what I'm trying to say, I don't want the parent to have that fear of having to give up their fight because they're going to get hit with harassments. Does that make sense?
Yes.
Thank you.
Thank you, Rep. Members, any other questions?
I have just a quick question for Haley. Thanks, Haley, for your assessment of this legislation. Do you think that it would be better suited, instead of including this subsection within harassment and the broader general harassment statute, that it would be a separate section, or including it where we're specifically saying harassment, however it's titled, but then we can go into detail about the elements and even defining terms? Because I see what you're saying. The vagueness is because we're trying to include this in the general harassment statute. What are your thoughts on that?
Well, I think the measure as written does clarify that the disruption or interference is specific to education workers. So I would say that not another complainant or victim could argue that a disruption or interference is harassment. But I think if the committee's intent is to really focus on some of the behaviors that are unique to school situations, unique to maybe the parent and teacher dynamic, then perhaps a separate statute that can better articulate the behavior that we're speaking of with some clarity might be more prudent. Because what will happen is this is potentially compromising the integrity of the entire harassment statute. There are, like I said, are already measures where education workers are classified separately, where there are enhanced penalties, so perhaps building on that or doing something. But again, I think more of a focus on the specific behavior that you're trying to criminalize is going to be important, because when we get into not only the freedom of speech, but the vague and over breadth of language in statutes is another constitutional challenge that can invalidate the law completely. So
I agree. Thank you. Thank you, Chair.
Thank you for that question. Members, any other questions? Especially if you have like testimony about legal advice, please submit that on time so we have time to digest it. We're not all lawyers here, and so we need time to assess it.
no, and I apologize, Chair. Our office this week alone has submitted over 50 bills, so we're trying our best to keep up, but I apologize. So we will try our best to get it.
Thank you. Okay, moving on to the next bill, HB 1592. This is with regards to educational workers and sports official protections. First up, we have Deal E, offering testimony and support.
Hello, Chair Woodson, Vice Chair Lachiko, members of the committee, Keith Hayashi, Superintendent testifying on behalf of the Department of Education. The department stands on its written testimony in support of this measure. Thank you for being here.
Next, we have testimony from Dr. Neal, Charter School Commission, offering testimony and support in person.
Good afternoon, Chair, Vice Chair, members of the committee. Ed No, Executive Director of Charter School Commission, and we also stand in support on this measure.
Thank you for being here. We have HGEA offering testimony and support in person.
Chair, Vice Chair, members, Nui Sebas with HGA. We'll stand on our testimony in strong support of this measure. Thank you.
Thank you so much. Next, we have HSTA offering testimony and support in person.
Mahalo, Chair and Vice Chair, will stand on our.
Thank you. We have Lanai High School and Elementary offering testimony and support. Mr. Boyer via Zoom.
Aloha, Chair and members of the committee. Can you hear me?
We can hear you.
Okay, my name's Doug Boyer, and I'm the principal of Lanai High and Elementary School, and I want to thank you for the opportunity to testify in strong support of HP 1592, also known as Natalie's Law. This bill is just not a policy, it's a necessary response to what educators across Hawaii are facing today. In the past 5 years alone, I have had, as a school principal, I've had to contact law enforcement 3 separate times because of their serious threats and aggression towards me in my role as a school leader. In one incident, an individual held a stapler to my head in front of students. I have been threatened with retaliation, including being told someone would have their sons come and find me. I've also endured repeated harassment from an angry parent, to the point when the parent came onto campus in an aggressive manner. I had to hide in an office that was not mine, and Maui PD had to come and ensure the school's safety. As I've heard, no educator should have to experience that. As a principal, I've also had to remove individuals from campus who were threatening staff, and I have dealt with parents entering athletic practices and yelling at coaches. In my years of being a principal at school athletic events, I've also had to remove spectators from harassing officials and coaches. In some cases, a police department was involved. These situations just don't affect adults, they also affect children. Educational workers are also increasingly confronted outside of school. Educational workers have been verbally harassed by community members in public spaces, at the grocery store, at the post office, at the beach, while they're just going on with their daily life. Harassment and threats do not always end at the end of the school day. I've also experienced threats from community members who have made statements about coming onto campus to harm students. When schools are forced into lockdowns or emergency action, the trauma impacts the entire school community. I also want to acknowledge the support I've received from the Hawaii Department of Education during these difficult and traumatic situations. DOE leadership and staff have worked with me to ensure proper safety procedures are followed, to provide guidance and to support our school community when incidents escalate. Even with that support, these experiences demonstrate why stronger legal protections are needed so educational workers are not left vulnerable while serving our students. This environment is driving educators educators across the nation out of the profession. Increasing threats and hostility are contributing directly to staffing shortages and openings across our school system. If we want a stable, safe schools, we must protect the people who serve in them. HP 1592 provides meaningful accountability for strengthening penalties for assault and threats against educational workers and sports officials. I would strongly urge that when violence or intimidation causes a school to activate emergency procedures, these acts should rise to a felony level seriousness. Natalie's law sends an important message that Hawaii will not tolerate violence against educational workers, their sporting officials, or the school communities they serve. I respectfully urge you to pass HB 1592. Mahalo for your time.
Thank you, Principal. Next, we have Principal Mina Kame from Kaneohe Elementary School in support. Actually, it's not in person. We have testimony in support from Hawaii Roosevelt High School. Also, Waikea High School Athletics in support. Mauna Loa High School in support. UPW offering testimony support. Individual Hawaii High School Athletic Association offering testimony support. And about 14 individuals all offering testimony support. Anyone else wishing to provide testimony, please come up.
Aloha again, Tiffany Edwards Hunt from Cal Middle School. I'd like to talk about passion. So I'm a very passionate person. I'm also a parent of athletes, both in high school. I have 2 sets of pom-poms. I go to all the games, and I consider it my duty to turn it around when it starts getting really negative. Like I'll say, okay, ref, we accept, because you can feel the crowd turning on people. And it gets scary sometimes. And so yes, my children are deeply embarrassed by me bringing the pom-poms, but it has, for my daughter, it's been 4 years, so now the whole school is used to it, and my son's now getting used to it. But it's strategic. It is to try to keep it positive at Cal High School. That's not my school where I teach. But at Cal Middle School, I want to tell you something. As a teacher, you can hear moms screaming, and yes, it's a whole family, a line of children, and I know that woman's passion. But when she's calling people effing bitch and scaring office ladies, and then when the guy is showing up from the backside of Hawaiian Acres calling my principal a fat blah blah blah, like, here's the thing. I am a big proponent of free speech, First Amendment rights. I have a background in newspaper and journalism. We are on a school campus trying to teach children. Many of our kids are coming from homes of trauma. So we are trying to reprogram them that this is not how we resolve conflict. And when you have to steer your class away from an area because a parent is going off the Richter, that's where we're crossing the line from free speech. And so I really need everybody to understand, like, what kind of environment we teach in, and the office ladies, that's HGEA, the principal, they're having to deal with these people who are unreasonable to the point of scary. Then they'll go online, and yeah, they'll take that picture of the sleeping teacher, they'll blow it up, and then someone's threatening them at Foodland when they're just trying to shop. So things are out of control, and we need to reel it back in. Thank you so much. And yes, I have a lot of passion.
Thank you for your testimony. Anyone else wishing to provide testimony for this measure, HB 1592? Okay. Seeing none, members, are there any question? Oh, please come up.
Good afternoon again, Chair, Vice Chair, and members of the committee. And again, our apologies. I believe our written testimony did come in a few hours late yesterday. But thank you for the opportunity to comment. Similarly to our last testimony, we do want to just be very clear. The Office of the Public Defender unequivocally supports our teachers, our educational workers, our sports officials, and that is not the reason for our opposition. Our testimony does highlight, and we just want to make sure that the committee knows that there are already existing offenses, as I referenced in my last testimony. What would normally be a misdemeanor assault or a misdemeanor terroristic threatening is already under our current statutory scheme an elevated Class C felony if it is committed against an educational worker or a sports official. So we do have these laws, and maybe it is a matter of educating our community so that deterrent factor that we've already previously legislated is better advertised. We also believe that we should be mindful of the fact that we're dealing with the aftermath of the conduct, and it really sounds like what the goal is here is to be more preventative. Increasing penalties or adding new laws, especially when we already have similar ones on the books, may not be the best way to achieve that. So I will be available for questions, and we stand on our written testimony, and thank you for the opportunity to comment.
Thank you for being here. Anyone else? HB 1592. Seeing none, members, are there any questions? Okay, go ahead.
Public defender, please. Hi there. You just closed by saying this bill is not the best way to address the situation. So in your mind, what is?
Well, I think as we indicated in our testimony, in being responsive to what it sounds like the community, and without being presumptive, what the committee is trying to address is prevention of this behavior. Because by the time it gets to us, or by the time this bill matters, an alleged crime has already taken place, meaning a threat has already occurred, an assault has already taken place. And we, as we did cite in our written testimony, creating new offenses has very little deterrent effect. Studies show that, and again, like I said, it doesn't sound like it's widely known, which is understandable because most people, as their chair pointed out, are not lawyers, much less criminal lawyers. But there are already statutes on the books. There are already criminal offenses in place that have recognized exactly what this committee is trying to do, which is to protect our educational workers and now, by extension, our sporting officials, and there's already a statute that we've referenced in our testimony that does that as well. So if it's deterrence that the committee is trying to achieve, perhaps education or sharing with our community members about the existing enhanced penalties for these offenses may be a start. We've also just anecdotally, we are not in the business of this, but just as community members talking about more prevention steps, education and security and de-escalation. Because like I said, by the time it does get to us, something has already happened. And it sounds like what everybody is in agreement on is that we don't want to be in this situation in the first place.
Sure. Okay. I know you cite a lot of criminal justice theory in your testimony about deterrence and whether it's effective or not. I think I'll just put that issue in the parking lot. We'll just have to agree to disagree on that. But when you talk about there's already enhanced penalties available. If this is a Class C offense. Walk me through the courtroom. Say this is a first-time offender, commits this assault. You guys charge it as a Class C offense. They have no criminal record. What are the chances that person is going to serve jail time? And I believe the maximum is 5 years in that setting.
Right. So there's so many factors that if the prosecutors elect to charge an individual with an assault, and the complainant is identified as an educational worker who's covered by the existing statute, it's a significant difference than being charged with a misdemeanor. Misdemeanor offenses carry a maximum penalty of up to a year in jail. Generally, you can get what we call a deferred acceptance of a guilty plea for a misdemeanor assault. For an assault in the second degree, which takes it to a felony offense, and without getting into the weeds of how different and how much more serious a felony conviction on somebody's record would be. First of all, an assault in the second degree is not deferrable, meaning unless there's an amendment given by the prosecutor's office or you go to trial and you prevail, you cannot keep this offense off of your record. So it will be a lifelong felony conviction. Secondly, you could get probation if you have no record. But again, I'm hesitant to give blanket answers because there's so many nuances that the court is required to assess when imposing a sentence. But it can range from, to be candid, no jail, but at a minimum 4 years of probation. The minimum probation for a felony offense is 4 years, and it can be 5 years in certain situations. As a condition of probation on a Class C felony, the court can impose up to 1 year of jail And when we say jail, we're talking about our community correctional centers like OCCC.
Sure.
Alternatively, the only other option for a court, if someone is not deemed eligible or appropriate for probation, they would get what's called the indeterminate 5-year term, which means under our sentencing scheme, you will get an open 5-year prison term. The paroling authority will decide how much of that you must serve before you can become eligible to ask for parole. But yes, you could serve up to 5 years, and any time that you serve that you maybe are granted parole, like if you serve 2 and are granted parole, you will be on parole supervision for the remainder of that open term. So it is drastically different from a misdemeanor.
Sure, understood. I appreciate you explaining that. I wish we had someone from the prosecutors to share their perspective as well. But are there times where there is a Class C charge pending and the defendant decides to try to get a plea bargain? And if that's the case, is the likelihood that there's not going to be any kind of jail time? And I'll explain to you where I'm going with this after you respond.
So the plea bargain process is an integral and necessary function of the criminal system.
Right.
Of the thousands of cases that our office handles, and I would say that the criminal system handles, a very, very, very small percentage of those cases actually go to trial. So plea bargaining and resolving cases short of trial is a necessary function. What I can tell you is that a plea agreement can never be entered into without the agreement of both parties. So if I, as the defense attorney, have a client who's charged with an assault 2nd degree, and I seek a plea agreement in order to resolve the case for my client ahead of a trial, I would need the consent and the agreement of not only the prosecutor's office to agree to whatever agreement I'm asking for, whether it's an amendment of the charge, a reduction of the charge, a guarantee of no jail, or a guarantee of a certain amount of jail, and then we'd also need the court to bind itself to that plea agreement. So it is a multi-step process that we as the defense attorneys and the defendant cannot achieve on our own. We need the cooperation and buy-in of the prosecuting agency.
Okay, thank you for that. And I know as a matter of principle, your office is going to be opposed to mandatory minimums. I recognize we have overcrowding in their jails as it is. You want to give the judges some discretion with sentencing. I totally understand that. But even if we could agree that enhanced penalties don't deter every offense, like what kind of message do you think we're sending? Like, I don't want to reference the Moanalua incident specifically because it's an ongoing case, but what kind of message would it be sending if that assailant serves absolutely no jail time for that horrific assault?
I think that there is a lot of different possible messages. There are so many nuances, and again, to every single criminal case, right? The act itself is obviously incredibly problematic if it reached the level of criminal prosecution. But why we are generally oppositional to mandatory minimums is it does not take into account what we call the big picture and all of the underlying factors. This is not to excuse the behavior, or not does it mean that it'll result in a not guilty of the behavior. But the reason that we're oppositional to mandatory minimums is that it binds the judge's hands. Sometimes we have complainants, which I know the committee may find hard to believe, but I've been doing this for almost 20 years now. Sometimes complainants don't want our clients to serve jail for a variety of different reasons, because the defendant has either availed himself of treatment, of therapy, of rehabilitation, has a family, a job, small children, and going to jail for 30 days, as this measure proposes, would disenfranchise that individual and put everybody perhaps off in a worse place. So we want the court to have the discretion. The court could give 30 days or 5 years. That's not to say this person would not get jail, but we just want the court to be in a position who actually sees the case from start to finish. Felony cases go on for a very long time sometimes, months, and for the more serious offenses, years. And in that time, the judge gets to know the defendant, the complainant, the case, the facts, and all of the circumstances that would lead our courts and the judges that we have faith in to render an appropriate sentence. Okay.
I guess my concern again is just as a society, like what kind of message are we sending? Like say this case, this case, hypothetically speaking, runs its course, the person serves no jail time. then this has obviously gotten a lot of attention, right? So if people are fans and they know, oh, this guy committed this vicious thing, caught on film, right? And then he essentially served no jail time. Like, what does that say to sports officials that are out there, educational workers that are trying to do their job, when they know that someone that just committed this horrific act served no jail time? There's no deterrence in that sense. It just seems to encourage this kind of, behavior that we don't stand for as a society.
And I appreciate the comment and the question, and I think, as you said, we may disagree on some of the elements of deterrence, but I think what I can say, and one of the goals of our office, which is hard and really is something that, takes exposure to the system, is the penalty for a felony offense is not limited to jail time. Sometimes we have clients who want to go to jail because it's easier for them. Probation for 4 years, being a convicted felon, limiting job opportunities, housing opportunities, education opportunities, custody issues, divorce proceedings, the list goes on and on, citizenship issues, deportation, immigration issues. The punishment for a felony offense and other offenses generally, in our opinion, is not limited just to jail. That is a punishment. That is an easily recognizable punishment that our community understands. But that is only one punishment from being a convicted felon, which already exists for educational workers.
Okay, well, I appreciate you being here and sharing your
Thank you.
perspective. Thank you,
Thank you for the opportunity.
Thank you. Members, any other questions?
Sorry, turn.
Please go ahead.
Thank you. For HSTA, thank you so much for your testimony, and to the teachers and admin staff who also testified as well. I understand the importance of this legislation. I think it also opens up a question to what is being provided for teachers as far as de-escalation techniques or potentially safety plans, any type of preventative measures that are being taught to teachers or are being created around teachers to assist with maybe trying to stop some of these things before passion takes over.
Well, one thing I will say is teachers, we are skilled in de-escalation because we do it all day. That is something that we have to do. So definitely if we're rising to this area with this, what we're encountering, we're trying those tactics. We're getting our administrators involved. I know I'm very lucky to work at a school where my administrator has my back. If I say I'm uncomfortable with a parent, if I say I'm feeling threatened, we'll make a plan and put it together. But I will say, as Libra Chapter President, I supervise 3,000 teachers from Kaha to Pearl City, and that your mileage may vary on how that support is given in that space. We are given, all teachers take a 1 hour, it's not 1 hour, it's how long is the little YouTube video? It's like a harassment training every year to start the school year that we watch, just to kind of remind us of that piece. And I also think it's been important, the focus on mental health and social emotional learning. So I think these skill sets, I can take my breaths in a conference, but I will say, when I say you have to hear from practitioners, the game has changed since COVID. I've taught for 21 years and I feel like a brand new teacher in dealing with some of these post-COVID realities. That I've supported teachers where we walked into a conference and a parent says, I'm getting you fired today. And I'm a professional with a degree and a master's degree, who's very good at my craft. But just the idea of that idea that you could walk in and do that or expect that that's the reaction you get. It's a different ballgame.
Okay. Thank you.
Members, any other questions? Go ahead.
Department of Education, please. Thank you, Superintendent, and again, happy 40th birthday. Yes.
25.
25. Obviously that incident happened on a campus of a DOE school, Moanalo High School. What steps have you taken to try to rein in unruly spectator behavior at OIA sanctioned events?
Thank you. Let's see, administrators, school principals with the athletic administrators in OIA, they review their safety plans. That's one thing. I think our statewide, our athletic administrators and our principals have a good sense on the pulse of the school. If they have the flexibility during preseason games to get additional support if they need, whether it's contracted security personnel, or law enforcement, if need be, during as well as during regular games. So, you know, if things come up, you know, during the course of, even before the game, if they hear things, they're also able to get additional security personnel. So those are some of the things. I think also, not only in the OIA, but across all leagues, there is discussion going on related to what's appropriate spectator behavior. And as our administrators or folks see things starting to escalate, what are the next steps that they're going to take? And so those discussions are going on not only in OIA, but actually across all leagues. Because I think what's important is that we have, once consistency is set for all spectators across athletic events, that's really important. I think expectations are also really important to have in place for those who come and observe our students. You know, we really emphasize to our student athletes and to all of our students that we're accountable for the choices that we make. You know, teamwork is important, sportsmanship is important for all of our students. So it's really important that the adults also exhibit those behaviors, because our students are watching, you know, and when individuals choose to cross the line and start to get very emotional to the point where they it may escalate into something else. I think our students are watching, not only our high school students, but other students, elementary kids who come to the events. You know, so I think it's really important that expectations are set and we hold our adults, especially, to a very high standard, because that's important for all. That consistent message is important for all of our students.
Okay, thank you, Sue. Is there currently a code of conduct that governs spectator attendance at these events? I mean, I assume they don't have a right to attend.
We do have, the department does have, we have a visitor code of conduct. The code of conduct, though, is only as good as we can enforce it. And that there are expectations for individuals that attend the events. Parents, for example, all of our student athletes, one parent is responsible for attending a meeting with the athletic administrator or with the coach to be sure that, I believe they still watch a video on what is expected and what is good parenting, and rephrase that, not good parenting, but what's expected of parents, yeah, in supporting their student athlete. The thing, though, is that many individuals who come to athletic events may not be parents. It may be an uncle or an aunt. It may be a community member that didn't have the opportunity to participate with the athletic administrator. So it's important that we have the guidelines and then appropriate consequences to deter behavior that is not appropriate.
Is the department considering, like, is there signage posted at like a gym, for example, saying, you know, by entering you agree to abide by these conditions, this is a zero tolerance environment?
Yes, I believe there is signage, especially our visitor code of conduct. I know in one league, it was at one point, that, and I'm not sure it's still there since I was a principal, it was let the players play, let the coaches coach, and let the officials officiate. You know, and let's have a great game, and you know, show them sportsmanship.
Sure.
But since then, we revised that, and the visitors code of conduct is posted in the athletic facilities.
Thank you. One of the suggestions that the public defender made was just to increase security at these events. What are you considering, or is the department or even the board considering with regard to hiring private security or other things to assist?
When the administrators deem that there is a need for additional security, you know, that flexibility is there for them. However, that does come at a cost, you know, and there are different costs associated with different types of security that you request. Contracted security might be one amount that you pay. The county police is another, you know, and it's very different. And so there are definitely costs associated with them. But if our administrators are really good, again, at getting a sense of pulse of the school, and especially if there are events that perhaps emotions run high, because of, you know, there are friendly rivalries between schools. But I think it's really important that we set the expectations for the spectators that come, and that, you know, they are guests. We want everyone to enjoy themselves. But when it gets to the point where folks are becoming verbally abusive or, you know, lead to other things, that just cannot take place at high school events or any kind of school events.
And each school would pay for this out of their own budget?
Yes.
Okay. Okay, thank you, Chair. Thank you, Superintendent.
Thank you.
Any more questions from members?
Question. Oh, sorry, one more. Superintendent, one more quick question. Happy birthday.
Oh, thank you.
If it's your birthday, happy birthday. I guess my question, kind of following up on the line of questioning that I asked HSTA, it seems like a lot of the professional development or training and support that's given to teachers is done at the school level. And they are required to bring it in, they are potentially required to pay for any of that extra training. At what point does the department step in to provide any of that extra PD or support or specific, like specialized trainers?
For teachers or for?
For teachers, for anyone on school campus that is dealing with whether it's a parent that's coming in or it's at a sports activity.
There are trainings, different kinds of trainings. I believe for our school administrators, for certain teachers, special needs teachers, there is this de-escalation QBS training. For elite counselors, that's on a request by the school, and again, any kind of training that's brought in, there is a cost for that.
And that cost comes out of the school's budget, or does the department cover any of that?
It might depend. It might be at the school level. It might be at the complex area level. It depends what kind of training is involved.
Okay. Thank you.
Thank you.
I have a question real quick.
Go ahead.
So, we're talking about security and how it's up to the schools to kind of determine, is that what you just stated?
Currently, yes.
So if they need to, basically ramp up their security, right? And so I guess my thing is that because of the high profile events that have just, you know, or the most recent one that has taken place, and, you know, this is obviously a really big issue. In the meantime, while we're trying to pass legislation, this is already a liability for the schools because you're basically put on notice, right? That these things are happening and we obviously need to address it. So do you think that there should be some sort of a, I guess, school-wide policy or something with security as far as keeping the premises safe? Because I don't think that passing legislation such as this, even though if it's considered a deterrent or not, is going to solve this by itself. I still think that we need to keep our school grounds safe, especially when it comes to our gyms and, you know, where all these things are taking place. So I don't think it's one or the other. It needs to work in conjunction, and would you agree?
I think, you know, looking at as I shared, the administrators, working with their school communities, working with teachers, coaches, our school personnel have a pretty good sense on the pulse of the school. So I would say that our schools are safe. I think that there are situations, though, that may arise that, for example, related to athletics, that an individual may choose to
Yeah,
get excited.
I don't mean to interject, just to clarify where I was coming from as far as, you know, the policy, because it's like, I feel like a lot of the burden is being put on the administrators to, and they're doing an excellent job, you know, currently with trying to manage
but I just feel like, you know, say, for instance, if there's a big football game, special duty police, or, you know, that sort of thing, right, where it's policy across the board. And so just a thought that that's maybe something, if you guys are not already currently doing some sort of blanket policy.
So as of right now, the discretion is left up to the school principal. As a former high school principal, you know, we did have games that we would work in conjunction with community policing. That you know, maybe we hear of things happening or might be happening. You know, we would work with our community police officers, and you know, they'd come in and support the school. Thankfully, nothing happened. You know, but not for every game, because you know it depends. I think as a principal, our principals have a good sense on, and our athletic administrators on what if there is an event that we may need heightened security, that definitely is their call to make, and they've been doing a really good job at that.
Thank you so much. I appreciate that.
Thank you, members. Any other questions? Okay, seeing that, we're going to go on to the next bill, HB 1888, Educational Worker Safety. This is our third bill thus far. First up, we have DOE offering comments.
Chair Woodson, Chair Chico, members of the committee, Sean Tajima testifying on behalf of the Department of Education. The department stands on its written testimony which provides comments on this measure and would request one additional amendment that was not in our written testimony. The department requests that volunteers and contracted staff be removed from the definition of educational worker to allow the department time to put procedures and training in place for the DOE staff first. Thank you for the opportunity to provide testimony on HB 1888.
Thank you so much. Next, we have AG's office providing comments.
Good afternoon, Chair Woodson, Vice Chair LaChica, members, and Chief from the Department of the Attorney General. As we noted in our testimony, the department was concerned by the language assist educational workers with any legal actions, that could be construed as providing legal assistance, which could include civil lawsuits relating to harassment. So we provided a clarifying revision in our testimony. Thank you. I'll be available for questions.
Thank you so much for being here. Next, we have Charter School Commission, Dr. No, offering testimony, providing comments.
Hi, good afternoon, Chair, Vice Chair, members, Edno, Executive Director, Charter School Commission. I appreciate the opportunity to be included in this measure, as charter schools are part of the public education system and providing safeguards and measures for educators so they can be deterred from the harassment. Thank you very much.
Thank you for being here. Thank you for your testimony. Next, we have HGEA, offering testimony and support. Thank you. Next, we have HSTA, offering testimony and support.
Good afternoon again, Chair and Vice Chair. We stand on our written testimony, but we'd like to specify that in this bill, what we appreciated was actually like the steps that would be taken. I think about myself as a teacher, I can't afford to retain a lawyer. So the idea of knowing what would happen next in that space, I think is really important. And I also think it's important because this language has been brought back year after year by some really strong advocates who believe in it. Thank you.
Thank you for being here. Next, we have individual testimony from Inger Stonehill in person.
Aloha. Aloha, Chairman Woodson and Vice Chair Teresa Chica. Here we are again. So, as a teacher, I'm always having to pivot. So I sit here, I had my written testimony that I was going to read. But after hearing some of the things that have been said, I'm pivoting. So excuse me while I read my phone. So some of the discussions and questions that came up, I wanted to address. And I'm going to start off with something that Chair Woodson had said a few years ago when we were here in this space and said, what will it take? Does someone have to get hurt? Well, here we are. So for my own personal experience. I was not physically injured, but I was harmed. My mental health suffered tremendously, and that harm has been long-lasting. I wanted to address something that the person from the courts addressed. I'm living proof of what happens when that line is ignored. I have a pending criminal trial against my harasser since 2024. It's 2026. So for 2 years, I've continued teaching. I carry on because that's what we do. But it's constant uncertainty for me. It's like waiting for the other shoe to drop. That ongoing fear is its own form of harm and trauma. I also wanted to just address just a little bit about passion and harassment. Passion is advocacy. That's what I'm sitting here doing, is passion, right? Harassment is intimidation. And I feel like that is at the core of it, the difference between that two. Passion does not create fear. I'm not yelling. I'm not calling anybody names. Harassment does, and that's a big difference. And yes, I've been a teacher 20 years. Of course, students and parents have the right to be passionate about their kids, as well as I've been passionate about my own daughter. So I wanted to address that. So just to round it out, this bill has been here a couple of times, and I really hope that we can try to address some of these issues and make things accountable and have something in place so that it doesn't happen to other educators. I may not still be at the same school that it happened to me at, but I'm still suffering. And I want to have other teachers not have to go through the same thing. Thank you.
Thank you for being here. Thank you for your testimony. Next, we have individual testimony from Mrs. Chambers in person.
Hello, Chair Woodson, Vice Chair LaChica, and members of the committee. I just want to thank all of you, especially Representative Woodson, for introducing this bill again, now for the third session. When people ask me about what I went through with the harassment, the threats, the TRO hearings, and ultimately the ongoing institutional betrayal by the DOE, I tell them I felt like I was drowning in the deep end of the pool. I could see everyone watching, and I could see the life preserver hanging on the wall behind them, but no one was willing to throw it to me. What I realized as I was drafting testimony for today is that someone eventually did, and that was Representative Woodson. For many of us, this work is about turning survival into something bigger by helping others and trying to prevent the same harm from happening again. At its core, HB 1888 does three important things. First, it creates a clear response system, an actual process so employees are not left guessing what to do in moments of crisis. Second, it ensures accountability and follow-through. When behavior escalates into threats, stalking, or intimidation, it cannot be treated as a private matter that employees are left to handle on their own. And third, it creates consistency. Safety should not depend on which administrator someone happens to work under. HB 1888 matters because it shifts us from reacting after someone is hurt to being prepared when harm occurs. It is worth noting that the judiciary's legislative package includes bills that authorizes public employers to petition for TROs and injunctions against employment-related harassment, citing the rising threats targeting public officials. These proactive bills cover state leadership like the governor, department heads, judges, and lawmakers. It does not include state workers like educators. I hope it's something we can consider, whether it's this session or next, for those working on our front lines, like all of you. HB 1895 and HB 1592 provide important legal protections for educational workers, but this bill, HB 1888, completes that picture by addressing accountability. Existing laws cover harassment and assault, yet without a clear DOE process to respond and to hopefully pursue elevated charges when appropriate, those protections fall short. I also want to acknowledge the Senate for introducing a similar bill, which I reference in my written testimony. Given the 80% similarity in language found in SB 3179 Compared to HB 1888, it shows a shared recognition across chambers that current DOE systems are insufficient. And I just want to close by thanking you for continuing to move this bill forward and for giving victims a seat at the table.
Thank you for your testimony. Thank you for your advocacy. Next, we also have individual testimony from the principal of Kaneohe, not here, but in support. Another principal from Manoa High School, also in support. And notably individual testimony from Catherine Payne, we'll know her, in support. I see late testimony, not late testimony, but from UPW in support. And several individuals all providing testimony in support. Is there anyone else here wishing to provide testimony for this measure? Please step up. Just state your name and your affiliate. Okay, if you could come up and just say that. First you. Because the microphones are directional, so we can't hear you.
So sorry, Tiffany Edwards Hunt, and I support it. I just need you to know, I support everything on this agenda today, but we're at the secondary schools conference and we're running out of time. So we're trying to stick it out to testify on everything. But in case we don't, I emailed you to say we support every single thing on this agenda today. And thank you so much for helping us.
Okay. Chair, exercise your discretion and accept that. Thank you. Please come up.
Angela Melody Young, testifying on behalf of CARES in strong support. So helping educational workers handle harassment requires clear documented procedures and a plan of action to help create safe environments while providing training and guidelines. And so, when things escalate in a high energy environment, especially at school, it's maybe because teachers and their friends didn't speak up for each other. So, having counseling between teachers as a first step to facilitating drama at school can also be very helpful because at school we need healthy relationships to get to our goals together as a community. Okay, thank you.
Thank you so much for your testimony. Anyone else? Okay, seeing none, members, are there any questions? Vice Chair.
For the DOE, I'm going to read to you a portion of the testimony from Ms. Iwamoto from Honolulu High School. In the aftermath of this incident, I found myself navigating a complex legal landscape entirely on my own. This included interacting with HPD and detectives, researching TRO, seeking legal counsel. While DOE is supportive, there is currently no formal procedure or roadmap for employees who are targeted by outside actors while on the clock. Similarly, we've heard and read testimony that echoes this sentiment that it almost feels like in that environment, once they are threatened or no longer feel safe, that they're left entirely to navigate this alone, like almost solitary. So what has the department done in terms of a safety plan, in looking at the current structure, and looking at staffing to make sure that this is more department-led and supported, to ensure that no employee should ever have to feel like they can no longer do their job in an environment where they feel threatened?
Thank you for that question. The department has developed a standard of practice for workplace harassment by non-employees, and we have it drafted and completed. It's currently in consult and confer. So it does include procedures such as that on when there is an incident that happens, the department would provide guidance on how to access a TRO and create a safety plan for the individual.
Can you explain to committee members what the consult and confer process is, and when is the plan going to be either made public or distributed to all the bargaining units or all the employees?
Hopefully soon. So the consult and confer process is we provide the document to the unions to look at, to give us feedback. So once everything is agreed upon, then we can share with the public.
And do you have an estimated timeline as to when you would like the safety plan completed by?
Estimated about a month from now.
HSTA, have you been able, can you come up please? You can just stay, you can just stay. Is the current safety plan, has it been shared with you? Are you able to provide input on the?
I think that would be something for negotiations, but I can check with it.
Thank you. Thank you, Chair.
Thank you, Vice Chair. Members, any other questions? Question for DOE. Is the DOE aware that for certain state departments, they have legal advocates that help their employees with technical assistance like getting TROs if they need? Are you aware of that?
I'm not aware of that.
If that's something that you can verify to be true, would you be amenable to also incorporating that into your practices?
That would be to have a legal advisor?
To have an advocate that helps with employees acquire things like TROs. Because the paperwork could be quite tricky sometimes.
So the other departments that have the advocates, they work in, they don't may ask, in what capacity? Or we can look, if you let me know which departments, we can go reach out to them.
Well, there are departments that work with families, and sometimes there are tricky situations, and so in those instances, they have advocates that help their employees receive the type of legal protections that they need.
If I might check, I can ask, maybe after the meeting, if I can get some more information.
Sure.
We definitely can reach out and see what.
And so if that's, it seemed to be accurate, is that something that you would support? In terms of incorporating into your practices?
I think we would need to take a look at the scope of what how they're interacting with the folks that they represent. I think the department is always open to looking to support our employees, but I would just need more information before making a commitment. But definitely looking to support our folks is important.
Okay, thank you so much. I had a line of questioning, but if you're not aware, then I won't continue. But thank you so much.
I have a quick question, Chair, if you don't mind, just a quick question for the superintendent. So do you guys have in-house attorneys within the DOE, or do you guys rely on the Department of the Attorney General to provide legal counsel?
The Department of the Attorney General.
Okay. Okay, thank you. That's all. That's the only question. I do have a follow-up for the Attorney General's office if you're okay with that.
Go ahead.
Chair. If the Attorney General's office can hold, thank you. So I know one of the thank you so much for being here. One of the criticisms, I think, not to address the specific facts of the current case, the high-profile case that's going on, but one of the criticisms from HGA when that happened was that the Department of the Attorney General was not stepping in to also advocate for the administrator. And so what is the Department of the Attorney General doing generally to keep our administrators safe, or if a situation like this occurs, how are you guys stepping in to advocate or even advise the DOE on matters such as liability? Because I do feel like just hearing some of the testimony today that they're trying their very best to facilitate this and come up with a security plan, or that's not even what was said, but I'm thinking that's probably the thought process from what they're saying. And I feel like there needs to be some sort of legal intervention as far as advising them on these matters, because this looks like tremendous liability for the state, just based off of the current situation. And so do you have any status updates as far as what the attorney, this might be just a very big question for your purpose for this bill, but maybe if you don't know the answer, just if you could take that back to the Attorney General, and because I am concerned about maybe potentially the lack of advising and just the lack of interaction and engagement maybe, so I would really appreciate that. Thank you.
I will certainly take it back and get back to your office.
Thank you.
Actually, I can provide it to the.
Yeah, that would be great. Thank you.
Thank you, Representative. Members, any other questions? Okay, seeing that, we're gonna go on to the next bill, HB 1825. This is with regards to emergency hire licensure. First, we have Deal E, providing testimony and support.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Tammy Chung, Deputy Superintendent. The Department of Education supports this bill. I just wanted to give a little bit of background information about emergency hires that are not commonly known. The department hires emergency hire teachers when a licensed teacher is not available. We always search first to fill the positions with a fully licensed teacher, or a teacher with a provisional license, which would be a new teacher in the first 3 years. Emergency hire teachers have a bachelor's degree, and while in the classroom, the teachers receive support for our induction and mentoring program for new teachers. They participate in professional development, and they receive an annual evaluation. The teachers can be renewed from year to year based on satisfactory performance, and if a position is available, once we've tried to recruit a fully licensed teacher for the position. Emergency hire is an important way to meet immediate needs for the classroom, and it is also a pipeline for our residents into teaching, since a majority of our emergency hires are hired locally in state. This bill extends the number of years that someone may teach as an emergency hire. Currently, it's limited to 3 years, and someone can no longer be hired on the conclusion of 3 years, unless they've obtained their license at that point. We have a recommendation that is not included in the written testimony, and that is to strike or amend the requirement for active pursuit of licensing in each year of employment. Currently, the requirement that a teacher show evidence each year that they are actively pursuing a teacher license is burdensome on the teacher, their administrator, and the Office of Talent Management. The department recommends removing the requirement entirely, or requiring that the teacher demonstrate active pursuit after a number of years rather than annually. I'm happy to answer additional questions. Thank you.
Thank you for being here, Dr. Chung. Next, we have HST offering testimony and support.
Hello, Chair, Vice Chair, Severally Untitled Chapter on behalf of HSTA testifying in support. Actually, in 2017, when I was hired, even though I had 11 years experience, I was an emergency hire because it took me a long time to prove that my Texas teacher's license, even though I had taught for several years, was real. So I understand what emergency hires go through. We're all here fighting the teacher shortage crisis. That's what we're working on, and this is a bill that can go ahead and help and support that. I will also say again, in my capacity as Labor Chapter President, we have a ton of emergency hires on the coast because we're trying to get people into classrooms. We want to grow our own educators. I will also say I see, especially with Hawaiian immersion teachers, struggling to finish their program in enough time, and we know these are areas that we want to go ahead and fill. Myself, I'm a computer science teacher. We're kind of hard to find, so we want to make sure that we can go ahead and get people into these spaces. I have an incredible science teacher at my school who did Shamanon's program during COVID, and we're still trying to fight to get her license. So it's a thing when we have people who are willing to do the work, who are good, that kids love, we want to keep them, and if extending this timeline helps that, we're all for it.
Thank you. It's insightful testimony. Next, we have Hawaii Teacher Standards Board offering testimony in opposition.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Felicia Villalobos. I'm the Executive Director of the Hawaii Teacher Standards Board, testifying on behalf of the board. The board submitted written testimony in opposition of HB 1825. The Hawaii Teacher Standards Board respectfully opposes HB 1825 due to concerns about its duration and the learning loss and academic gaps experienced by students taught by emergency hires who lack full preparation and credentials. Long-term reliance on emergency hire permits allows positions to be filled without the credentials, training, and experience necessary to protect instructional quality and student services. Emergency hire permits are intended to address short-term urgent staffing needs when no qualified candidates are immediately available. Extending these permits to 5 years fundamentally changes their purpose. A 5-year time frame is not an emergency measure. It effectively functions as a permanent appointment, similar to HTSV's 5-year standard license. While many emergency hires are hardworking and well-intentioned, limited preparation can result in less effective instruction, weaker classroom management, and reduced ability to identify and address student learning needs. This concern is especially significant given that there are over 1,000 emergency hires, which most emergency hire positions in Hawaii are currently concentrated in K-6 elementary and SPED, where students are at critical stages of development. In the elementary grades, foundational skills such as reading, writing, and math, as particularly vulnerable, inadequate instruction can lead to regression or learning loss rather than progress. Over multiple years, this learning loss compounds and can have lasting effects on students' academic growth, especially for students with disabilities who require specialized instruction, legal compliance, and consistent, highly trained teachers. Research consistently shows that licensed teachers are associated with higher student achievement and stronger long-term academic and social-emotional outcomes, often equated to substantive yearly gains. Research further indicates that months of learning loss can accumulate into years of academic delay when students are taught by unlicensed teacher over multiple years. In practical terms, a kindergarten student under a 5-year emergency hire permit could be assigned an emergency hire teacher for most of their elementary education, while a middle or high school student could experience an emergency hire teacher throughout their entire academic career. Approving a 5-year emergency hire permit sets a troubling standard by normalizing temporary measures as a long-term staffing solution rather than addressing root causes such as recruitment, retention, compensation, workplace satisfaction, targeted supports in high-needed areas, and additional supports needed to transition emergency hires into fully qualified teachers. For the past 3 decades, the teacher shortage has been a long-standing issue. The emergency hire permit predates the establishment of the Hawaii Teacher Standards Board. In the past 3 decades, what supports our employers and key stakeholders who provided testimony today, providing these educators? Greater emphasis should be placed on assisting these teachers who already hold a bachelor's degree and love the profession of teaching in completing an 18-month or 2-year licensure program, instead of adding another Band-Aid to our crisis that will ultimately impact the learning of students for generations to come. Thank you for your commitment to maintaining high standards and protecting the educational needs of all students.
Thank you for your testimony. Next, we have testimony from the Executive Office of Early Learning, providing testimony and support in person.
Hello, Chair Woodson, Vice Chair LaChica, and members of the committee. I'm Yuko Arikawa-Cross. I'm the Director of the Executive Office on Early Learning. Thank you for this opportunity to share our support for this bill. Thanks to the support of the legislature, the governor, the lieutenant governor, and our Ready Keiki partners, the number of public pre-K classrooms has grown rapidly over the last several years. Highly qualified EOEL public pre-K teachers must have graduated from a state-approved teacher education program, or SATEP, and hold a teaching license in early childhood education. This is a unique set of qualifications for which there has been no significant demand prior to the expansion of the public pre-K program. As the system adjusts to these new opportunities, some candidates, some of which who may hold a bachelor's or a master's in early childhood education from a non-SATEP program, encounter challenges obtaining an initial early childhood license due to limited number of approved pathways and the timing of enrollment of opportunities for existing programs. We appreciate that this bill addresses current challenges while maintaining a defined time-limited structure to ensure that emergency hire permits serve as temporary bridges to full licensure, not as a parallel or permanent hiring pathway.
Thank you for your testimony. Next, we have testimony from the Charter School Commission offering comments.
Chair, Vice Chair, members of the committee, Ed No, Executive Director of the Charter School Commission. In addition to the comments which we submitted, we definitely appreciate the urgency, the issues of having shortages and the issues that derive from that. However, our comments are focused on the fact that we do recognize that it can impact teacher quality and student outcomes and defer to the Hawaii Teacher Standard Board on this matter. Thank you so much.
Next, we have testimony from the Hawaii Coalition of Immigration Rights, offering testimony and support in person. Indivisible Hawaii, J20 in support. Ka'u Voices, Hawaii Island Chapter in support. And we have Indivisible Hawaii in support. Several individuals all offering testimony in support. Anyone here wishing to provide testimony on this measure? Please come up.
Hello, my name is Haley Swanson. I am the English teacher at Taylor Cafe. I just completed my licensure. I was an emergency hire until December of this year, or last year. My school has incredibly high turnover. We're on the Big Island, mostly due to cost of living. If we lose a teacher mid-year, or if we do not fill a position, our students are stuck with a long-term sub. We have many, many emergency hires, like I said, I was one of them. We're people who want to teach, we're people who are working towards licensure. We want to be there, we're working hard to be there. A sub isn't. What's really impacting our students' learning is having a sub who doesn't care. I have several students who, for several months, were without an English teacher, or without a relationship teacher, right? These are kids who want to go to college. That puts an undue burden on our students, whereas we could have teachers who want to be teachers filling these positions. So, thank you so much.
Thank you for that testimony. Anyone else, please come up.
Aloha. Tiffany Edwards Hunt, Cal Middle School. We have a teacher shortage in our school as well. We're anticipating vacancies. And here's the reality. I totally appreciate what the Standards Board is saying, but there is like the hope and then there's the reality. And Haley is absolutely correct. You can't, if you don't have an emergency hire, you're gonna have sub after sub after sub, and these kids suffer. And the teachers who have consistency and routine, we end up suffering because we're like, hey, that behavior is not acceptable in this room. And so we're constantly having to fix things as a result of someone else not having that position filled. The other big thing to understand is that some of our charter schools, I worked in a charter school, so I was interested to hear what the Charter Commission had to say. If they don't have the ability to get a sub, they will put an educational assistant in the room in order to cover a class. We are in a critical stage where we need to make it attractive for teachers to live and work in Hawaii, and this needs to be part of the package. And yes, as the Teacher Standards Board was saying, there's other fixes, but we need everything because boots on the ground will show you that there are people that are in our classrooms that do not give our kids the care and concern because they're in one day, out the next. It's super important that we make it possible. Also, a lot of educational assistants do not have college degrees, and so they need to get a college degree in order to get a teaching certification. So it's very complex. If we give people more time, that they'll be able to follow all of the hoops that we put before them. So thank you very much for the opportunity. Aloha.
Thank you for your testimony. Thank you. Anyone else wishing to provide testimony on HB 1825? Seeing none, members, are there any questions?
Chair,
Okay,
I'm
please go ahead.
sorry, I had my hand raised, I didn't know. Sorry, my name is Doug Boyer, principal of Lanai High in elementary school. And being in rural Hawaii, we do find a teaching shortage, right? And I understand that though teachers might have they have a harder time to access various campuses, and it actually takes longer for them to earn their teaching degrees or their credentials, right? And I am in support of the 5-year extension for emergency hires, because at Lanai High and Elementary School, we have to rely heavily on the J1 program. And with that J1 program, as teachers have been working towards getting their teacher certifications, where Hawaii is 3 years, but if it's extended to 5 years, that will help us fill potential openings we've had. Since I've moved here, we have been 100% fully staffed due to the J1 program. And we are looking at J1 teachers who are, they're coming in with doctorate degrees, master's degrees, 10, 15 years of experience, master teachers in the Philippines. And with that being said, they are providing a great educational opportunity for our students here on the island of Lanai. So with that being said, I am in 100% support of this bill. Mahalo.
Thank you for your testimony, Principal. Anyone else? We have 22 individuals all providing testimony in support. Okay, seeing none, members, are there any questions? Go ahead.
Department of Education, please. We just have a series of questions, and I just want to preface it by saying that I fully recognize this is a supply side issue. That's not the department's purview or kuleana directly, but I'm very sympathetic to HTSB's arguments about every student deserving to be taught by a highly qualified teacher in the classroom. And the part that pains me is the fact that a lot of these unlicensed teachers seem to be in Title I areas, rural areas where academic achievement might lack from the statewide average. So I just want to set that out there. I recognize this is beyond the DOE. How many emergency hire teachers are there right now, roughly?
There are currently 1,054.
Okay, and how many licensed teachers do you folks have?
We have about 13,000 total teachers. So that would be, we're at about 99% teachers being licensed.
99%?
Sorry, take that. Sorry. We went over this earlier.
96 or 97.
Okay, 96 or 97% are fully licensed, or have a full license, a provisional license.
I'm sorry, does the math add up to there's 1,000 emergency?
Hire teachers out of 13,000.
Isn't that like 7%? Ish.
We get the idea.
Point well taken. But I guess just, the question I guess I have is just generally speaking, at what point does like an emergency teacher, this emergency workforce become just part of the overall structure, no longer really an emergency?
So maybe emergency hire is not our best description of what we should have. What we're really looking at here, so let me start by saying our goal is to have a licensed, highly qualified, effective teacher in every classroom. So there's no dispute about that. Our hiring process is structured to recruit those kinds of teachers. So we only hire under emergency hire when a licensed teacher is not available. So for example, if a classroom is currently taught by an emergency hire teacher this year, we will post that position for next school year to recruit a licensed teacher first. So the position would only be filled by an emergency hire if we were unsuccessful in recruiting a licensed teacher. So then the question becomes, what's the alternative if a licensed teacher is not available? The alternative becomes having a substitute teacher, and that is not no diss on substitute teachers because they're really important to our structure, but you really, we're looking for more consistency for our students. And also if you have a emergency hire teacher, they're receiving support and training throughout the year, as opposed to a substitute who just come in for the day and not participate in that longer term planning and training. So we will, the question is, what's the alternative? What the bill proposes is to extend the potential for these teachers to continue. And when we can extend it, it means that someone who has knows the school, has been performing and been trained, had received training but not yet licensed, they could potentially be renewed for additional number of years rather than having to recruit a new emergency hire teacher who is brand new and has to be retrained. So there would be So in those cases, you're hiring someone who has a known record of their performance. And we do want our teachers to become licensed, to speak into the supply side issue. And so I think maybe that answers your question for now. I have more I could say, but.
Yeah, that's fine for now. And you know, as someone who moonlights as a substitute teacher, I take no offense by your statement. You want to aim a little bit higher. Perfectly fine. What kind of measurable progress do you folks require of these unlicensed teachers to make progress toward that licensure of the 1,000 that you have?
So currently the law requires that every year the teachers show that they are in active pursuit of their teacher license. So they have to show evidence that they've been accepted to a program and our transcript work that shows that they're making progress toward either the post-baccalaureate certification or some kind of master's degree or something in a state-approved teacher education program. So that has to be provided annually from to be able to continue their emergency permit.
Okay, and how do you define progress? I mean, do they have to are there certain benchmarks you folks require of these unlicensed teachers besides just enrollment in a program?
So there's two parts. One part here is that the teachers, I think we should let the Teacher Standards Board speak to the active pursuit criteria. Oh, Assistant Superintendent Sean Bacon is going to come up and explain for them.
Thank you for the question, Representative Garrett. Sean Bacon from the Office of Talent Management. So currently right now on an annual basis, teachers have to show what it's called demonstrate active pursuit. So what they do need to show the department on an annual basis that they are currently enrolled into a program and are continuing enrollment in that particular teacher preparation program, or if they may need praxis testing types of things, they would show their praxis scores that they've either attempted the praxis and have not been able to complete it, or have actually showed us a completed praxis that meets that requirement too. So there's different measures that we are looking at depending on each individual situation.
I guess we should also say that one thing that's required of every emergency hire for continuing is that they're evaluated. And so they have to actually show that their performance in the classroom is meeting expectations.
Correct. So, and part of our teacher assignment and transfer process every year that happens too, that's part of the HST collective bargaining agreement is that if there is an emergency hire in that classroom, we do post that position for all tenured teachers to have an opportunity at that position first. If there is no then applicant, then it's up to a principal's decision whether or not to look at extending that emergency hire teacher or not.
Okay, have there been times you've turned away an unlicensed teacher, say from year 1 to year 2, because you've determined they haven't made sufficient progress toward licensure?
There are opportunities, yes, when if a person is not performing well, principals have let us know that they plan not to extend that person beyond that first year.
Okay. I guess my concern is extending this from 3 to 5 years. It just kind of embeds this temporary workforce within the structure. I mean, again, I recognize this is fully a supply side issue. We need to do more to encourage, developing this teaching profession. But my concern is that people are just going to procrastinate, and rather than year to year make progress, recognizing that the department needs teachers. That there might not be a lot of scrutiny as to that level of progress. And we're just kind of extending this out for 5 years. And as I said at the beginning, the onset, the concern is that the areas that need highly qualified teachers the most are not getting it.
So we are currently surveying all of our emergency hire teachers. The survey's in the field right now, but of a third responded quickly. And of the 1/3, 60% or about half or more than half said that they would need they need more time would help them to complete their license, and also that reasons are the cost of pursuing their license, so they have to pay for courses, for example, or the workload, so they're trying to juggle being a new teacher and taking courses at the same time. So about 50% said they would be more likely to complete their license if they're able to have a little more time. Okay. We do know of cases where people have been effective in the classroom, just haven't been able to complete by the 3rd year and have had to be let go.
Okay, and then over time, is this emergency workforce growing, or do you see like it kind of stabilizing?
I think we have seen the numbers increase over the last few years of emergency hires. I think it's a nationwide issue of teacher preparation programs around the nation are not putting out as many teacher candidates, but I think really what we're trying to do here is really grow from our local pipeline here. And I think as we mentioned, many of our emergency hires are coming from our local communities. We want to see what we can do to better support our local communities, and hoping that this can be an option for some of our administrators. You know, the goal is hopefully they don't have to use all 5 years, but if we get to a point where they do need that additional time, that's what the hope of this bill is for.
Okay, thank you for the background. It's very helpful for me to understand challenges you folks face. And again, I recognize that this isn't entirely a situation of your own making, but thank you for the background. Thank you, Chair.
Thank you. Members, any other questions? Okay, quick question for first, I guess, DD. How many substitute teachers do you have approximately at any given time?
I need to look up that number. I don't have the number off the top of my head on this.
So a rough percentage? There's 1,000 emergency hires. How many substitutes do you have any given day?
Are you talking about ones that are being used on an annual day, or just how big the entire pool is?
In the classroom.
We definitely have to look.
Yeah, I'd have to get that information. I don't have the number on the top of my head.
Does anyone know? No one knows. Okay. All right, thank you so much. I have a question for the standards board, please. Oh, actually, DOE, I have one quick question. You said that you want the provision regarding active pursuit to be taken out of the proposal. What is the reason for that? Regarding, that's the provision that states that the emergency hires should be pursuing their licensure through the course of their time teaching.
So just to be clear, we want our emergency hires who are going to be teachers to get their license, and in a timely way. I think the issue is with the requirement that it be provided annually, the evidence be provided annually.
What is the issue with that?
I think sometimes on the annual basis, it can be sometimes of a burden on the teacher, or also it puts an additional workload on the Office of Talent Management. Sometimes at the time that they're trying to provide their active pursuit, it's right in the middle of our busy hiring season. It sometimes can put a delay on having these teachers hired, but we do understand the quality, and we would like to do what we need to do to ensure what's best for our teachers as we move forward here.
Okay. I appreciate the honesty, but I'm not sure that's a good reason. One more. Hawaii Teacher Standards. I appreciate your testimony. I agree with a lot of it, but to play devil's advocate, what about these substitute teachers? Or what about our emergency hires that are showing to be effective, loosely defined, but then after the 3 years they leave the classroom and then is replaced by a even less qualified and experienced emergency hire or substitute?
Does the devil need an advocate? I'm just kidding. No, good question. So I think it comes from 2 points here. We have about 20,000 licensed teachers under the Hawaii Teacher Standards Board, and as you heard, there's about 13,500 teachers with HIDO and charter. Why are they leaving? So we've been on national conversations with other licensing agencies. It's a retention issue at this point. So when you ask about numbers and they're growing in emergency hires, teachers are leaving. And I can give one scenario, because I taught elementary for 15 years on the island of Hawaii. When there's an emergency hire or more than one in your grade level, guess who gets to take care of them? Guess who gets to support them, answer their questions when their mentor's not around or the principal is busy? So it's another burden on the teacher that now I have to prepare this emergency hire. So the numbers may be bigger, as you said. We don't certificate substitutes. And right now, to be a substitute, all you need is a high school diploma. So with the emergency hire being at over 1,000, then you add in the substitutes and long-term subs, that's a huge amount of unlicensed teachers in the classrooms. So what can we do to support someone who, and we found unfortunately recently, within the last few years when I took over as executive director, people were calling us saying, I only had 3 years, no one told me. I'm like, wait, what do you mean no one told you? Our licensing specialists get phone calls saying, oh, I thought, I got it until I got licensed. No, it's 3 years you were doing every year, or not renewing, you apply for a new one every year. So that monitoring factor is very important. So we actually put safeguards in our application process, or congratulations, you're on your circuit emergency hire permit, you only have 1 more left. To notify them that they should be enrolled in a program, because some of them didn't know they had to be enrolled in a program pretty much year 1. Again, they have a bachelor's degree, so it's an 18-month program or a 2-year program if they're getting a master's degree. We understand that life happens. There is a suspension of the rules in our administrative rules that allow for, we have people with emergencies, like medical emergencies, they're allowed to get another 4th emergency hire permit. So what are we doing to support our teacher candidates? And this is something we have to bring back to the board and the educator preparation programs. What wraparound services are we providing these teachers? And maybe it's a test, not all educator preparation programs require testing. Some of it is content knowledge through coursework. They get the 30 credits and they get a degree in that content area. What are we doing to support the teachers if an educator preparation program does require testing? Are we providing support in testing? There's a lot of testing services out there that do tutorials. Are we paying for the praxis for them? Because we covet them so much, we want them to be a part of our school community. We'll pay for the praxis exam. I'll pay the $20 to get them tutoring. What are we doing together as stakeholders to help these folks navigate college so they graduate on time, so they finish their program in time? Sometimes the educator preparation program has to be a little more flexible. What we've noticed in preparation, if I wanted to be a teacher today, some preparation will allow that open enrollment, that rolling enrollment. I can enroll and start class tomorrow. Some of our institutions have not that flexibility. They go, well, that course is not going to happen until every even year or every odd year. So that's where that 3-year emergency hire permit kind of, yeah.
In what jurisdiction are they doing those prescriptions that you have articulated?
Say that again, what?
In what jurisdiction? You said that you attended a lot of national conferences. Correct. And so are they doing any of that stuff anywhere?
For the 5-year or supporting?
About any of the solutions that you just...
Some of them have about 200 preparation programs in their state, which makes it taxing for the state agency to monitor all those. They're looking at the for-profits that are popping up, that are asynchronous, online. Can you get your license with $500 as quickly as possible? Now, they're saying, research is showing that those are leading to non-retention. Because when you face a classroom, it's not asynchronous. It's live humans, eyeball to eyeball. And if you don't have the strategies, you're not gonna last in the classroom. So other states, I'll give an example, Maine, I just found out, took away the praxis exam. Now, we have a mixture, you can either take it or not depending on your program. They took it all away. And now they're looking at putting it back in because the quality of the workforce has gone down. And it's been 5 or 6 years. So when we talk about other agencies, I talk with accreditors, and all of us as state licensing agencies go on these accreditors' monthly calls. We also go to conferences and talk from licensing agencies and educator preparation program. We all kind of bounce ideas what is happening. Just today I was on a call with one of the states, I believe it was Ohio. How can we get our EPPs more online with what is needed in there in a quicker fashion? Because sometimes the review process of an educator preparation program can take a while. Because you're trying to match national standards. Do they have everything in place? Is the clinical there? Are they in the right situation? Are they meeting the state standards? Every state has their own standards for licensure. So the conversations happen nationally with different agencies. We're not unique to the United States of America. However, I haven't seen a lot of states go 5-year emergency hire.
So are there any jurisdictions that are doing what you're prescribing? Because you're making the argument that it's better not to have these emergency hires because of these other solutions are available. Are there any jurisdictions actually taking advantage of any of those type of solutions that you're
things. Each state is run by districts. Usually because we're one big district, we're going to be unique. So it's going to be up to that district and that admin in that district of how they're preparing the workforce. Some of them are becoming their own educator preparation programs, and they're actually training them at the school. They actually develop their own EPPs. And so that's another national conversation of, as let's say in Tennessee, there's a school district, there's a high need of emergency hires somewhere in a rural area. They're actually building their own educator preparation programs to train the teachers for that community, for their need. And it depends on the state. Sometimes that license is encumbered to that district area, so they can't move it around because They don't want to spend all this money preparing a teacher and then they just leave to another district or state. So that's one solution I've heard. Another one, again, the conversation is apprenticeships. Because when you pay for someone's education, that is usually a barrier for a lot of the EAs or people from the community to go back to school and pay for a master's degree or a bachelor's degree or something else. So they're finding that, again, we just got back from the National Register Teacher Apprenticeship Conference. I went to at least 10 or 12 different states, 90 to 91 to 93% retention rates when they put in a registered apprenticeship program within their
What is the issue with our
district.
apprenticeship program that we're trying to stand up?
Say that again.
What is the issue with our apprenticeship program? that we're trying to
I
stand up
believe
in
we
the
just
state?
finished, the Department of Education and the union just finished their consult to confer, so
That's
I haven't
finished.
heard next steps just yet, that was just recent. So hopefully we hear something back soon.
Thank you. Members, any other questions?
Quick question.
Yes.
So thank you so much for responding to our data request from our January 15th hearing. I know you sent that in yesterday. So the data is kind of in different tables, but what I was able to gather, and if you just respond to this if this is correct. So we have 7,520 licenses and permits. The applications that were submitted in the 2024 to the 2025 school year to HTSB. Among those, 2,000 or so were licenses and 1,900 were permits. Among those that were approved, among the 7,500, we have 2,000 licenses and 1,900 permits were approved, so about 3,900, which is about 52%. So to make it easy, let's say 50%. So only 50% of applications are approved. How are we then, are you currently working then with either the department, or what are you doing with kind of this data for us to be able to see that, okay, one out of every 2 applications results in some type of denial or some type of failure? And if we have 1,000 to 2,000 teacher shortage, but we have 7,500 applications, it seems that there's a lot in the pipeline who are willing to become teachers, and so what are we doing with this data?
Yeah, so there's no denial. Denial actually goes through misconduct and administrative rules, chapter 90, all that stuff. There's actually a hearing. And I gave you the numbers. There's been 9 denials of applications since 2008, I believe. So the applications you just mentioned are the new ones that came in. Again, we still have about 20,000 active licenses right now and permits. And that means some teachers already have a license that wouldn't be of that number because they're in their term of 5, 10 years, 3 years. So that's the renewal process. I did not include the renewal process in that. Like right now, we have about 5,000 standard license renewals. I believe that's standards and advanced renewals right now. So that's, they could hold a license from the Hawaii Teacher Standards Board as long as they meet the requirements.
So what happens to the 47% that do not result in a licensure or permit? What happens?
That's not a number, because the number I gave you is the new ones that apply. When people don't apply, they don't get a license. So those are all the applications processed and resulted in a license. Now,
yeah, so 7,500 applied. Out of those, 2,000 resulted in a license, 1,900 resulted in a permit.
Correct.
So the balance, which is like the difference, which is about 3,500, what happens to those?
There shouldn't be a difference, because again, any denial would be a sanction, would have to go on the website. So there's no denying unless someone is waiting for documents to be turned in.
Maybe
So,
I'm reading the data
Okay,
wrong,
okay.
but like if you can tell us among those that applied,
if they're licensed, if they have you granted a license?
yeah, because obviously you're not approving let me rephrase it. It's not resulting in 100% of applications resulting in a licensure or permit. So what is the percentage of folks that you're either failing, falling through the cracks, or for whatever reason else? And Assistant Superintendent, can you please come up and if you can just let us know do you work with HTSB on like tracking this data? So at least we know how certain things are either designed or currently designed to unintentionally, become a bottleneck for some of the folks who are in that pipeline and trying to get to licensure or getting to a permit. Do you get this data at all?
So I think what we provide is our office provides the amount of emergency hires we hire on a monthly basis to the standards board so that they're able to get that information and be able to track that information. I'm not 100% sure on your question. Can you, what you're
I think I know what she's trying to say is,
Okay.
so everyone has about 6 months to apply. It's because of the professional fitness questions, those might expire. So we ask like, have you ever been convicted of a felony, misdemeanor, so on and so forth. So if application is pending, it may expire but not denied because they're gathering paperwork. Sometimes this happens with reciprocity. If someone from Florida has a full license in Florida, but we need documentation to prove that, sometimes them getting a hold of that state agency in Florida takes a while.
Do you
It's another
currently
state
work
agency.
with Teacher Standards Board to track all these root causes of where people are, not able to, it's kind of impeding their process to get a licensure?
So I don't think we've had those in-depth discussions with the Standards Board on those types of issues yet.
Okay, thank you. Okay, that's it.
Okay.
Okay, I know we're running a little over, so we'll just, members, are there any questions yet for this? Okay. We're gonna move on to the next item on our agenda, which is, where are we on our agenda? Relating to the education, House Bill 1893 clarifies that public charter school teachers are eligible for incentives under the Teacher National Board Certification Incentive Program, increases the certification incentive from $5,000 to $10,000. So first up, we have Department of Education in support.
Good afternoon, Vice Chair Lachita and members of the committee. Sean Bacon testifying on behalf of the Department of Education. We stand in support of this, and any questions we're ready to answer. Thank you.
Thank you so much. We also have Executive Director Villalobos, Hawaii Teacher Standards Board.
I'm gonna have my licensing specialist, who's National Board Certified.
And yeah, if you're able to respond to the testimony, sorry.
Good afternoon, Vice Chair, committee members. My name is Tracy Idika. I'm one of the licensing specialists at the Hawaii Teacher Standards Board, a National Board Certified teacher. I've been a teacher since 1982, and I've been a National Board Certified teacher for over 2 decades here in Hawaii. I know firsthand the difference National Board Certification makes for both our teachers and our students. And I'm testifying today on behalf of the Hawaii Teacher Standards Board, which has submitted written testimony in support of House Bill 1893. The majority of my career has been spent at Aiea High School as a high school English teacher. That's my heart. And I believe that I was a good teacher before I became a National Board Certified teacher. But I know without question I was a better one after. The process changes you as a teacher. What you learn, what you understand, how you think changes. Research confirms this. Research shows that National Board Certified teachers improve student learning outcomes and also contribute to stronger school communities. That's why I've been involved in candidate support and expanding National Board opportunities since I first certified in 2004. It's about making a difference. Now there's 2 aspects in this bill. One is the financial, which of course is important. We want to recognize our teachers. But I do believe that the most important aspect of the bill deals with equity for our public charter schools. Currently, Hawaii Department of Education schools receive dedicated funding for their National Board bonuses. They don't need to use their per pupil funds to finance the bonus. Charter schools, however, have to use their per pupil funds in order to pay their National Board Certified teachers that bonus. That's not equitable because this has the unintended consequence of discouraging our charter school teachers from pursuing National Board certification. One charter school teacher who I know was so excited when she achieved her certification a few years ago. When she went to talk to her principal about the contractual stipend, he told her if he paid her, he would have to close a school program because that $5,000 a year that would go to her would impact the funding for this very tiny, small charter school. She left the school. She didn't want to hurt the school, but she also knew that she was entitled to that funding. And our charter school teachers need our national board certified teachers as much as all of our Hawaii DOE schools. NBCTs make a difference in our schools, and on behalf of the Hawaii Teacher Standards Board, I respectfully ask for your support of House Bill 1893.
Thank you so much. Members and our guests in the audience, we have about 1, 2, 3, 4, 5, 6. So we're trying to get through the rest of the agenda. If you can please keep your testimony brief, we would really appreciate it. Sorry about that. Next we have Hawaii State Teachers Association. Thank you so much. We have Office of Collective Bargaining in opposition. Anyone here? Okay. We also have Public Charter School Commission in support.
Chair and members of the committee, Edno, Executive Director, Charter School Commission. In addition to the support, just again wanted to echo what was shared earlier. I really appreciate understanding the complexities and the inequalities around this particular provision, and again highlighting the fact that this is, we humbly request that as we move forward with this, that the committee will consider amending the measure by including a separate appropriation. As you heard, it does come out of the per pupil, which is the only real funding source. So really, again, strong support, and ask that we could look at a separate appropriation. Thank you very much.
Thank you so much, Director. We also have 5 individuals submitting testimony in support. Is there anyone else wishing to testify on House Bill 1893? Okay, seeing none, members, questions? Okay, seeing none, we are moving on to House Bill 1890, collective bargaining, annual salary step increases. So first up, we have Attorney General offering comments. Oh, in offering comments. Next, we have DOE offering comments.
Chair, Vice Chair, members of the committee, Sean Bacon testifying on behalf of the Department of Education. We stand on our written testimony offering comments. Thank you.
Thank you so much. We have Director Colby, Budget and Finance, in opposition.
Good afternoon, Chair, Vice Chair. The department stands on this written testimony and is opposed to this. We're open to any questions.
Thank you so much. We have HSTA in support. Thank you so much. We have Office of Collective Bargaining in opposition. Not present. And sorry, did you want to testify? Were you the Attorney General?
Yes.
Yes, please go ahead.
Good afternoon, Jeff Kent, Department of the Attorney General, Chair, Vice Chair. You have our comments. Basically, we have some concerns about how the bill will affect Hawaii Revised Statute Chapter 89 and the collective bargaining structure. Thank you.
Thank you so much. We also have Kulani Hako High School in support, United Public Workers offering comments, and a number of individuals and teachers also offering testimony in support. Is there anyone else wishing to testify on House Bill 1890? Seeing none, I'm going to pass it on to Chair to manage questions.
Thank you, Vice Chair. Members, are there any questions? Okay, we've already had these debates, so seeing none, we're going to move on to the next bill, which is HB 202 with regards to community literacy labs. First up, we have is Superintendent's Office, Department of Education, offering testimony in opposition, it looks like.
Aloha Chair and Vice Chair, Terry Shijima, Assistant Superintendent, representing the Department of Education. We stand on a written testimony providing comments. Thank you.
Okay. Next, we have Hawaii State Public Library System offering comments.
Chair, Vice Chair,
please stand and support with intent and stand on our written testimony. Thank you.
Thank you so much. And we have testimony from 2 individuals, both in support. Is there anyone else wishing to provide testimony on this proposal, HB 2012? Seeing none, members, are there any questions? Okay, seeing none, moving on to the next bill, we have HB 1887. This is regarding artificial intelligence and education. First up we have is AG's office offering comments.
Good afternoon, Chair Woodson, Vice Chair Lucia, members, and Board Chief from the Department of the Attorney General. As we noted in our testimony, we pointed out some areas in the bill that we believe that more clarity is needed, and we've also provided some clarifying amendments in our testimony. Thank you. I'll be available for questions.
Thank you for your testimony. Next, we have testimony from the Department of Education offering comments. Please.
Terry Shijima, we stand on our written testimony.
Thank you so much. Next, we have Foundation for Individual Rights and Expression offering testimony and support via Zoom.
Yes. Chair Woodson and members of the committee, thank you. My name is John Coleman. I serve as a legislative counsel for the Foundation for Individual Rights and Expression. We go by FIRE for short. We're a nonpartisan nonprofit that defends free speech rights of all Americans. We're headquartered in Philadelphia. We support this bill because it takes a careful approach to AI policy. And we hope it helps students better understand that what AI can do and what it can't do, and that it will help show that human judgment, context, and responsibility still matter, especially as AI increasingly becomes part of everyday communication. AI is an expressive tool, and the people who develop and use it retain their First Amendment rights. And the First Amendment limits the government's authority to regulate how people communicate ideas, and First Amendment principles have long adapted to new technologies, from radio and television to the internet. And this means that people using this technology are often engaging in expression, like sharing or seeking information. Just as educators teach students how to read critically, write clearly, and judge the quality of information, teaching students how AI works is absolutely a step in the right direction. And for these reasons, FIRE supports this bill and its passage. Thank you.
Thank you for your testimony. And apologies, I have the Board of Education offering comments.
Good afternoon, Chair, Vice Chair, and members, Council employees, Executive Director of the Board. I just came up to say that we stand on our written testimony, but it's my first appearance. I want to be here in person. And the primary note is that the Board believes its constitutional responsibility is to formulate statewide education policy.
Thank you for your testimony. Thank you for being here. We have testimony from the Democratic Party of Hawaii Education Caucus offering testimony in support. And we have testimony from 3 individuals, 2 in support and 1 opposition. Anyone else? HB 1887. Okay, seeing none, members, are there any questions? A question for DOE. AI is becoming increasingly a part of most of our lives. Yes. And curious to know what the DOE is doing about preparing teachers to face this new reality. And we're seeing the use of AI for things like drafting papers or giving speeches, students giving speeches, and so curious to know what your thoughts are, just in general.
So thank you for that question. Since the onset of AI, when it first came out, the department put together a cross-office group together from Office of Technology. We have our curriculum office as the lead, and we've also included other offices, and we created staff guidance first because adults kind of need to know what's appropriate and what's not. And then we came out with student guidance. We've also done numerous trainings. We have an online introductory course to AI that's on our AI website that is open to all employees. We have done 2 summers of AI summits. The first summer, we had about 750 people, and this past summer, we had about 950. We also do reach out to complex areas, even schools, and we've gone to, I think, we've touched about 7,000-ish instructors. We also have started vetting tools, appropriate tools, because safety is our first concern for students. And one of our pilots has been Magic School. And with the Magic Schools, let me see my numbers. Sorry. Well, I think it's, how many teachers? About 1,700 teachers. And so this program trains teachers, and it also has modules that they get trained on so that they can start teaching students on how to use the AI appropriately. We also have a Enehana digital magazine that we get hits from around the world, actually. So we encourage all of you to also subscribe. We publish some of the latest information or tools that are coming out for AI. And our goal is to have someone from every one of our schools, or at least like 90% subscribe to this communication that we publish.
And when you say that you offer student guidance, can you go into a little bit of detail as to what kind of guidance you're providing to students regarding AI?
Yes, I'm going to ask Director Nakapui to come out. That's I meant to put that in my binder, but I don't see it.
Pulling up the guidance. So the guidance for students are,
yes.
Okay, so the guidance for students centers around, one second. So there are 5 areas that it centers around: seeking permission to utilize AI when it's appropriate for, obviously not all homework or tasks. Students should be using AI for.
When you say seeking permission from the teacher, you mean?
Yeah.
Okay.
And also, we have policy where if this, well, we just have general policy on technology use, but parents have to give permission for that. The second area is private and personal information. We share with students, or try to train students on when they should share that, when they should and shouldn't share personal and private information with AI. We also make students aware of bias and misinformation, also centering around our 4th area is safety and transparency and citation when they use AI in their work.
How do you ascertain when there's bias in the AI?
So, that's a tricky question. Our bias, so I guess it's in the way that the students utilize them, questions that they ask. We try to have our students be, so always check the information that AI gives them to verify that it's true or not.
And hopefully they're checking all information to see if it's true or not. There's biases more so in humans, I would imagine. Okay, thank you. Members, any other questions?
Yes.
Please go ahead.
Do you require parental permission before students use AI in classrooms?
So we have
or just teachers?
So we have a general TRUF and a TRUG form, a technology responsible use form and a technology responsible user guidance.
So it's in the packet of papers that parents got to sign at the beginning of the year. Okay.
Yeah.
Okay, good enough. Thank you.
Thank you, Representative. Any other questions? Please, seeing none, we're going to go on to the next bill, which is HB 1770, Department of Education and bus drivers. First up, we have Department of Education offering comments.
Chair Woodson, Vice Chair Lachiko, members of the committee. Shantajima testifying on behalf of the Department of Education. The department stands on its written testimony which provides comments on this measure. The department is fully supportive of any measures that are working towards increasing the number of bus drivers. For the past 6 years, we've seen a decline of 230 bus drivers. From last year to this year, it was the first time we saw a reversal in that trend with a gain of 69 bus drivers. We realize this is not enough to completely cover our inactive routes, but it does provide us with a positive trajectory that the financial incentives provided by our bus companies is making an impact. We realize that there are unique challenges for our neighbor island and rural communities in particular. We're committed to working with impacted legislators and community to find a way forward. Thank you.
Thank you for being here. Thank you for your testimony. Next, we have AG's office offering comments.
Good afternoon, Chair, Vice Chair members, and Ryuji. Because the bill creates a grant program, we suggest that the bill be revised to include appropriate standards to address that grant program. Also, for the repayment of grants and signing bonuses, we provided some suggested language, and we found some other technical amendments and also addressed in our testimony.
Thank you so much for being here. Okay, and we also have testimony from the Democratic Party of Hawaii Education Caucus offering testimony and support. We have 3 individuals offering testimony and support. Anyone else wishing to provide testimony, please come up.
Angela Melody Young, testifying in strong support. I think perhaps the legislation could consider an amendment to work with Director Sniffin's Department of Transportation office to see what is the best plan of action to move forward with addressing transportation needs in the school system, or consider an amendment to include the Department of Transportation Services. Because when you have offices that are working together, we can help each other navigate these procedures that require similar resources. For example, with the establishment of the School Bus Driver Outreach and Pathway Program, if you consult with DCS, the bus driver training is very similar. So for example, both drivers need a commercial driver's license of the appropriate class and a passenger endorsement to operate a vehicle designed to transport 16 or more people, including the driver. And so, however, drivers who transport primary and secondary school students to school-related events must also have a specific school bus endorsement. So it's an additional licensing requirement. And so by including in this legislation a collaboration with other offices that have similar priorities, it can help you get to your goals. Thank you.
Thank you so much for your testimony. Please note that the Department of Transportation is working with the DOE and they have been instrumental thus far. Anyone else wishing to provide testimony? Seeing none, members, are there any questions?
I have one question.
Go ahead.
And I apologize, I'm shooting from the hip here because my computer took a dump, so it's being fixed. But do you folks have guardrails in there to prevent should they go through this program, get their grant, get their license, to prevent them from leaving? As we know, school bus drivers don't get paid very well when compared to a tractor trailer. There's no difference in license except the school bus driver CDL has an S endorsement. But that same license, he can go out and get another job delivering pork chops or hauling aggregate for much better pay. If they went through this program, is there a mandatory minimum time they'd have to stay with the program?
According to the bill, it's an expectation of 3 years.
I saw the 3 years, but is it a mandatory thing? And if they leave before, do they have to repay the program to the DOE and or the grant? And again, I apologize. I had the questions, but my computer took a spill.
Yeah, referencing the bill that's included in the bill.
Thank you.
Thank you. Members, are there any other questions?
Chair,
Please go ahead.
I know we're running short on time, so I'm going to try to keep it brief. I think the heart of this bill is to try and address the bus driver shortage. On Hawaii Island in particular, it's hard because I feel like we're just pulling from different from other bus locations, whether it's tour bus drivers or from truckers or people that are hauling. But we still need to find a way to grow that pool. How many vacancies on Hawaii Island do you have as far as just bus drivers? I know that you kind of outlined the 230 drivers that you didn't have statewide, but on Hawaii Island, how many routes and how many bus drivers are you still missing?
So for Hawaii Island, the contracted drivers that we're looking for is 109. Current amount of drivers on Hawaii Island is 69. So overall, we're short 40 drivers. Thanks for allowing me to clarify that drivers and the routes. So in our contracts, we ask for X amount of drivers, which are more than the amount of routes that we have, because we want to have a bench. As drivers call out sick, you want to have a bench so that they can fill in, so that we can run the routes. So while on Hawaii Island, the contracted driver amount is 109, the total expected routes are 96, and our total active routes are 88. So currently we're short 40 drivers, but we're short 8 routes right now.
And then how many routes have you had to consolidate just in the last year? Because we've gone through this conversation, I think, a number of times at this point, and this current 109 is consolidated from multiple routes from even in the last 2 years, right? So these are already the most consolidated it's ever been.
Correct. So I don't have the exact amount. I can get that for you. And we're doing that on every island. So just to give you a quick background on that, because we're short drivers in the driver pool, ideally we want 1 driver per route, but because we're short, we figured out ways to just maximize the drivers and have them run double routes or triple routes. So while that's allowed us to fulfill a lot more of our routes, the downside of that is when a driver calls out sick, now instead of having 1 route down, you have 2 or 3 routes down. So we're just trying to maximize the drivers as much as possible to fulfill the routes.
Thank you, Chair.
Sure, one bit of good news for Hawaii Island, when we looked at the longitudinal, last year compared to this year for Hawaii Island, we've increased by 40 routes compared to last year. So we're not where we need to be, but we are making gains. We're still going to try to fulfill those routes.
And one of the biggest increases, or can you name one of the biggest increases that has led to this uptick?
It's mainly the financial incentives provided by our bus companies. So credit to them, they've been really receptive to our discussion and suggestions, and they've raised the pay. They provided signing bonuses. They provide paid training. They also guarantee X amount of hours. So I think the efforts of our bus companies has really resulted in that uptick. So it's been a downhill trend for 6 years and a significant upward swing. So we hope that it continues that way.
Thank you so much. Thank you, Chair.
Thank you so much. Members, any other questions? Vice Chair.
Just a comment. If you can please provide the committee with that breakdown of by island, the current number of routes, like where the short drivers, number of routes that were consolidated, and which of those routes you're actively using either incentives or also the Act 140 to continue to fulfill routes.
Okay, to get back to you.
Yes, you can get back to us. Yes. Thank you.
Thank you. Members, any other questions? Okay, seeing none, we're going to go on to the next bill, HB 2122, regarding teacher housing. First up, we have Deal E, offering comments.
Good afternoon, Chair, Vice Chair, members of the committee. Sean Bacon on behalf of the department. Department is just offering comments, and just want to mention that the department really supports any efforts to help with our recruitment and retention. I think with this bill currently right now, with the department really understands the intent of it, but it would just create some additional workload for the department. We would just need additional resources to help run this program as we move forward for it to be successful. Thank you.
Thank you for being here. Next, we have the Charter School Commission offering testimony and support.
Yes, the Charter School offers support on this. Thank you.
Thank you so much for being here. Next, we have HSTA offering testimony and support. And support, thank you. HGEA offering comments. We have Chamber of Commerce Hawaii in support. Democratic Party of Hawaii Education Caucus in support. Aloha United Way in support. And one individual offering testimony in opposition. Anyone else? HB 2122. Seeing none, members, are there any questions? Seeing none. On to the last bill, we have HB 1892. This is with regards to adding a teacher representative on the Board of Education. First up, we have the Board of Education offering comments.
We'll stand on written comments, Chair.
Thank you so much. Next, we have HSTA. Thank you. We have HGEA in opposition. Democratic Party of Hawaii Ed Caucus in support. EPW. Comments? That's all we have on our list. Anyone else wishing to provide testimony for this bill, HB 1892? Anybody else? No, I was kidding.
You and me on this. Aloha Chair Woodson, Vice Chair Lechika, and members of the House Committee on Education. My name is Julie Reyes-Oda, and I am a state representative from Ewa Beach, but today I'm giving testimony in my personal capacity supporting HB 1892. Prior to being elected in 2024, I was a teacher at Nanakuli High and Intermediate School, and I gave testimony at the Board of Ed month after month, year after year, so that policymakers would hear from a regular classroom teacher on the implications and effects of their decisions. But the only participation I had was a close-ended 2 to 3 minute speech on an agenda item called testimony. I could not participate in discussions or questioning, and often I felt like the decisions are already made before I got there. I ran for office so that I could have a seat at the table and be part of the discussion. As a state rep, about half of my bills are education or teacher related. And it's the reason why I came to work in this Capitol, was to work on education. And if I could have been a non-voting member of the Board of Ed, I might still be in Nanakuli talking about math for several hours a day, while getting knee-deep in educational statewide policy a few times a month for committee or general meetings. And in reading the testimony, some argue for this bill to consider giving other department employees non-voting seats on the board, not just teachers, because non-teacher employees are equally responsible for the educational achievement in our school system. I'd say that that statement is true, absolutely true. But this bill is just a start and should not be the end of the discussion on participation. All department employees contribute to the education of our kids, and they should also have a seat at the table. About 60% of our department employees are bargaining at 5, they're teachers. And if this bill passes, it opens the door for more collaboration and from other employees. I hope that we can support this bill so that we can continue to bring more seats to the table for other department employees, because the education of our kids depend on all department employees. Thank you so much for allowing me to testify.
Thank you for your testimony. Anyone else wishing to provide testimony on this bill, HB 1892? Okay. Seeing none, members, are there any questions? Seeing none, recess. we are reconvening. Now we're going to go into decision making. First up is HB 1895. This is with regards to educational worker protections. Members, we're going to defer this bill and we're going to fold this language into another proposal, so we'll defer. Next, we have HB 1595, educational workers and support officials. Remember, for this proposal, we want to pass this with the HD1. This is a better way to address the back end of this challenge as defined as if there is an alleged offense and that's transpired to be a legal violation. We're going to keep it going. I would like to add in the committee report that this is one part of the solution. We need to look at preventative measures, and we will be passing another proposal. Besides that, effective the date to July 1st, 3,000. Members, questions, comments, concerns? Vice Chair for the vote, please.
Okay, members voting on House Bill 1592. Chair's recommendation is to pass with amendments. Chair and Vice Chair vote aye. Representative Amato.
Aye.
Representative Evslin.
Aye.
Representative Garrett.
Aye.
Representative Capella.
Aye.
Representative Kila.
Aye.
Representative Old.
Aye.
Representative Muraoka.
Aye.
Representative Souza.
Aye.
Thank you, Chair. Your measures adopted.
Thank you, members. Going on to the next bill, HB 1888. This is again with regards to educational worker safety. Members, I would like to pass this proposing at HT1, starting off on page 2, under proposed language under 302A. I'm recommending that we change that shall to a may. This is with regards to employees not working when there's suspected harassment. We want to leave that to the schools to determine that on a case-by-case basis, so we'll change that shall to a may. Also, that's overlapped in charter school statute, which is under 302D, so we're going to make that same change, changing the shall to a may. Members, again, as mentioned earlier, we want to collapse HB 188 and HB 1895 together. And again, this is to better address both sides, both the preventative measures and also regarding the legal offense of harassment. And so regarding HB 1895, we're going to take that language out of section 2, and that's the language that adds to HRS, proposed language under HRS 711-1106, and that's regard to general harassment. Again, it just specifically mentions schools and school boards in that addition. And I want to add an additional section that says that the Department of Education shall have a legal advocate to help DOE employees with acquiring TROs. We'll add appropriation language to accompany that FTE, and we will defect the date. I acknowledge some of the conversation around some of the legal issues with the broadness of definitions, but we'll leave that for judiciary to decide. Questions, comments, concerns? Vice Chair for the vote.
Chair, members voting on House Bill 1888. Chair's recommendation is to pass with amendments. Chair and Vice Chair vote aye, noting all members present. Is there anyone wishing to vote no? Is there anyone wishing to vote with reservations? Chair, your recommendation is adopted.
Thank you, members. Going on to HB 1825. This is regard to emergency hire licensure. I appreciate the Standards Board's testimony. Definitely not an ideal situation, but members, I would like to pass this on, defecting the date. HT1, defecting the date. Questions, comments, concerns? Vice Chair for the vote, please.
Voting on House Bill 1825. Recommendation is to pass with amendments. Chair and Vice Chair vote aye. Any members wishing to vote no? Any members wishing to vote with reservation?
Reservations.
Reservations for Representative Muraoka. Chair, your recommendation is adopted.
Thank you, members. Going on to the next bill, HB 1893. This clarifies charter schools also are eligible for the National Board Certification Incentive Program and also increases the amount of that incentive. I'd like to pass this with the HT1, defecting the date to July 1st, 3,000. Questions, comments, concerns? Vice Chair for the vote.
Voting on House Bill 1893, Chair's recommendation is to pass with amendments. Chair and Vice Chair vote aye. Any members voting no? Any members voting with reservation? Chair, your recommendation is adopted.
Thank you, members. Going on to HB 1890. This is automatic pay increases for teachers in good standing. Recommendations to pass. This was HD1, defecting the date. Questions, comments, concerns? Vice Chair for the vote, please.
Voting on House Bill 1890, Chair's recommendation is to pass with amendments. Chair and Vice Chair vote aye. Any members voting no? Any members voting with reservation? Chair, your recommendation is adopted.
Thank you, members. Going on to HB 2012, Literacy Labs. Members, I would like to pass this with HD1 with some amendments starting on page 2 under sections 2, paragraph B. We want to change that shall again to a may. This is with regards to the DOE prioritizing this program. Also changing those shalls to a may with regards to what's required per that program. Besides that, we will defect the date July 1st, 3000. Questions, comments, concerns? Vice Chair for the vote, please.
Members voting on House Bill 2012, recommendation is to pass with amendments. Chair, Vice Chair vote aye. Anyone wishing to vote no? Any members wishing to vote with reservation? Chair, your recommendation is adopted.
Thank you, members. Going on to HB 1887. This is with regards to artificial intelligence education. Per the discussion that ensued during the committee, we will defer. Moving on to HB 1770. This is with regards to Department of Education and bus drivers. Recommendation is to pass this with the HD1. We will take out the section 4. This is with regards to establishing an outreach and educational pathway program within the DOE. We'll take that out. And per AD's recommendation, we want to add or incorporate standards with regards to the grant funding program, technical, non-substantive amendments, and also defecting the dates July 1st, 3000. Questions, comments, concerns? Vice Chair for the vote, please.
Voting on House Bill 1770, recommendation is to pass with amendments. Chair and Vice Chair vote aye. Any members wishing to vote no? Any members voting with reservation? Chair, your recommendation is adopted.
Thank you, members. Going on to HB 2122, teacher housing, recommending passing with the HD1. Section 2, page 3, lines 4 through 8. We'll take out that eligibility requirement. If this bill comes into fruition, we would like the administration to establish those parameters. We don't want to incorporate it into statute. Besides that, we will defect the date until July 1st, 3000. Questions, comments, concerns? Vice Chair for the vote.
Voting on House Bill 2122, recommendation is to pass with amendments. Chair and Vice Chair vote aye. Any members voting no? Any members voting with reservation? Chair, your recommendation is adopted.
Okay, last HB 1892, adding a teacher representative to the Board of Education. Pass as is. No, I'm just kidding. We're going to defect the date, July 1st, 3000. Questions, comments, concerns? Vice Chair for the vote.
Voting on House Bill 1892, recommendation is to pass with amendments. Chair and Vice Chair vote aye. Any members voting no? Any members voting with reservation? Chair, your recommendation is adopted.
Okay, thank you, everybody.